The Limited Liability Partnership Act, 2008. The Ministry of Law and Justice on 9 January 2007 notified the Limited Liability Partnership Act, 2008. The Parliament passed the Limited Liability Partnership Bill on 12 December 2008 and the President of India has assented the bill on 7 January 2009 and called as the Limited Liability Partnership Act, 2008. This act have been enacted to make provisions for the formation and regulation of limited liability partnerships and for matters connected therewith or incidental thereto. Introduction. The Ministry of Corporate Affairs and the Registrar of Companies, ROC, are entrusted with the task of administrating the LLP Act, 2008. The central government has the authority to frame the rules with regard to the LLP Act, 2008, and can amend them by notifications in the Official Gazette, from time to time. It is also to be noted that the Indian Partnership Act, 1932 is not applicable to LLPs. The LLP Act, 2008 has 81 sections and 4 schedules. The first schedule deals with mutual rights and duties of partners, as well limited liability partnership and its partners where there is absence of a formal agreement with respect to them. The second schedule deals with conversion of a firm into LLP. The third schedule deals with conversion of a private company into LLP. The fourth schedule deals with conversion of unlisted public company into LLP. Limited Liability Partnership Meaning and Concept. Meaning. A LLP is a new form of legal business entity with limited liability. It is an alternative corporate business vehicle that not only gives the benefits of limited liability at low compliance cost but allows its partners the flexibility of organizing their internal structure as a traditional partnership. Since LLP contains elements of both a corporate structure as well as a partnership firm structure, LLP is called a hybrid between a company and a partnership. LLP. New form of legal business entity with limited liability. Alternative corporate business vehicle. Allows the partners the flexibility of organizing their internal structure. LLP itself will be liable for the full extent of its assets. Liability of the partners will be limited. Important definitions. Body corporate, Section 2, d. It means a company as defined in Section 3 of the Companies Act, 1956, now Companies Act, 2013. Business, Section 2, e. Business, includes every trade, profession, service and occupation. Designated partner, Section 2(j). Designated partner means any partner designated as such pursuant to Section 7. Entity, Section 2(k). Entity means any body corporate and includes, for the purposes of Sections 18, 46, 47, 48, 49, 50, 52 and 53, a firm set up under the Indian Partnership Act, 1932. Financial year, Section 2(l). Financial year, in relation to a LLP, means the period from the first day of April of a year to the 31st day of March of the following year. For an LLP, Section 2(m), it means a LLP formed, incorporated or registered outside India which establishes a place of business within India. Limited Liability Partnership, Section 2(n). Limited Liability Partnership means a partnership formed and registered under this Act. Limited Liability Partnership Agreement, Section 2(o). It means any written agreement between the partners of the LLP or between the LLP and its partners which determines the mutual rights and duties of the partners and their rights and duties in relation to that LLP. Partner, Section 2(q). Partner, in relation to a LLP, means any person who becomes a partner in the LLP in accordance with the LLP agreement. Advantages of LLP form. LLP form is a form of business model which it is organized and operates on the basis of an agreement. It provides flexibility without imposing detailed legal and procedural requirements. It is easy to form. All partners enjoy a limited liability. Flexible capital structure. Easy to dissolve. Incorporation of LLP. Incorporation Document, Section 11. Incorporation by Registration, Section 12. Registered Office of LLP and change therein, Section 13. Name, Section 15. Reservation of name, Section 16. Change of name of LLP, Section 17. Effect of registration, Section 14. On registration, a LLP shall, by its name, be capable of suing and being sued, acquiring, owning, holding and developing or disposing of property, whether movable or immovable, tangible or intangible. having a common seal, if it decides to have one, and doing and suffering such other acts and things as bodies corporate may lawfully do and suffer.